to your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say. Just find your way and try to stay true. Just speak low, stand in your row. Try not to show this life's a show. Try not to glow. Way down below, it's a lot of woe. And that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say. Just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say. Just find your way and try to stay true, 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 true,
Hello. Happy hump day. Oh, no, today's not hump day. What's today? Thursday. Sorry. Tomorrow's Halloween. Oh, my goodness. I'm a little scatterbrained. Hold on. I have to sneeze and I don't want. Sorry about that. I don't want to sneeze in you guys' ears. Hi, everyone. Hey, Jennifer. Hey, Creative Minds. Neat Noodle, S. Hockett, Tracy. Good to see everyone. Thank you guys for being here. I appreciate it so much. If you wouldn't mind. Hey, Michelle. Just taking a moment and giving the girl a thumbs up. I'd appreciate it very much. All right. So I wasn't going to do this, right? But after I got off of Allie's live yesterday, last night, I got ready and I got ready for bed and then I went to bed and sorry, I got something in my nose. Hey Sarah Bellum, good to see you. Anyway, I just felt like unsettled because we didn't finish. It ended so abruptly. Then I had to edit it, then I had to re-upload it and I didn't like the way that it ended. And then I thought about okay, well, maybe I'll do a video, but I was like, no, I don't want to do. Hey, Allie, good to see you. Hey, Grandma Sherry, Kimberly, good to see everybody. Thanks for being here. I thought about doing a video, but you guys know how that goes for me. I am capable of making a quick video. I just don't, quite frankly. Hey, Bet. I just don't because it usually I want it the sound to be right and all the things. And I knew I was not going to be able to make a quick video with this one, even if all I did was just read. I knew it wasn't going to be quick. So I was like, okay, I'm just going to finish this. So we're going to finish it. No, Nita's not my finger in my nose. There's like something in the air. It's been really, really windy here. And I don't usually have allergies, but I don't know. All the wind probably, blew something in, who knows, that I don't agree with. So, I have already checked. We're going to start where we left off yesterday. We're going to watch the body cam footage. We were at the part where, with Lauren. So we're going to watch that. It's been redacted. Everything is good. I need to give a shout out to Sleuthy Goosey once more because it was Sleuthy. It's from her Google Drive. These are her documents. Thank you so, so much everybody, or thank you so much, Sleuthy, for all of the hard work because I have to tell you guys, redacting is not easy, especially when you're trying to redact a document that somebody is holding in their hand, as you're going to see in this footage, um, because um, you have to do the tracking. It's a big thing. And, as Hawkett, I grew up here. I've lived in Texas. I'm a Texan. I'm just back. And, I normally like, when I moved back, I didn't have any problems. It was just really, really cold. And, coming from Florida, it was really, really cold. And, last night was really cold. We got, down to freezing. And so, but I'm really, really excited. Hey, Kathy Four. Hey, Shelly Beans. Good to see you guys. Thanks for being here. Um, anyway, tomorrow's Halloween, and I get to take, the Tricky Nuggy, trick or treating. She came over and had dinner with me tonight, and then we decided that it should be a spend the night. So she spent the night, and bless her little heart, she is worn out, um, just worn out. So she was asleep. We didn't even get all the way through. Do you want to build a snowman? Like, she was asleep by the time, Anna sings into the doorknob, "It doesn't have to be a snowman." Out, out. So, um, yeah, so, let's get started. Okay, so, at this point in all of it, where we're at now, we're at CrimeCon, okay? Christina has been served officially. I looked it up. She does have to be before before the no contact order can be in effect, she must be served personally. It's not That's Utah law, and it did come out of it came the stalking injunction is out of Utah, so it goes by Utah law. So, Allie, I'm so sorry. Yeah, Jamie, I'm back. I'm back. I moved back last year. I've been here almost a year now. So, anyway, I, I, where we're at now is she's been served. Okay. I know that there's been a lot of talk back and forth about, should she have gone, all the things, right? Because her husband sent her screenshots of this order. She went to the Aurora Police Department to find out about what was going on. But at the end of the day, it's not official. That's why she wasn't arrested. And so now they're going to meet with Lauren and Grayson, and they're going to they're gonna, explain all of it to these two. This whole 9 minutes I find highly irritating. We watched it yesterday. I'm probably going to be as irritated today as I was yesterday. So without further ado, let's get going. All right. So now they're going to mill through the people. Let's just skip ahead to where they finally meet up with Lauren and Grayson. I mean, and the other thing I wanted to just remind everybody is that this is a packed place. You know, this happened in front of God and everybody, and right on the heels of whenever they were doing the Delphi presentation and they were told that they had added extra security. Look, see, people are even coming up to them, like this is, an issue. Like this was embarrassing. And, the fact of the matter is, um, that order says for her to stay back 500 feet. It doesn't bar her from every place in the entire galaxy or the universe, for the love of Pete. I thought this was just, I'm so irritated by this whole situation. Are they going to stay muted this whole time? No, here we go.
Provided them to you guys.
Lauren?
Good, how are you?
Good, good. Are you a Miss Lauren? Lauren Grayson. Okay.
Okay, let me just start out here. This I found particularly irritating yesterday, okay? And I find it equally irritating today. Why is Grayson speaking for Lauren? Okay, Lauren is not, Johnny Depp or, some big, huge celebrity that has a handler, for the love of Pete. Okay, this is ridiculous. Lauren, you took your ass to the courthouse to get this injunction. Why don't you speak for yourself? Like, this is so annoying to me.
Okay, perfect.
So, did you get a copy of this yet?
Yeah, we provided them to you guys.
Okay, so you already have a copy?
Okay.
So,
Okay, and there it is. We provided them to you guys. So if there was ever any question about who is the one that sent the email to the Aurora Police Department, there you have it. Right here, out of Grayson's own mouth, they sent them a copy. They wanted this to happen. They wanted her kicked out. This is so, ugh. Let me be quiet.
I'll give you another copy.
Hi,
So-
sorry.
Hello.
There was somebody walking by that
Oh, you're fine.
is friends with her, so I just wanted to look
So-
down for a second. I apologize.
My
No, that's
partner
fine.
and I, we explained everything to her, what she can and can't do, where she can be and can't be. And we thoroughly explained if she does violate it, she will be arrested.
And
So,
she understands.
yeah, we gave her, it's official, we served her, gave her a copy. I already have the NCIC hit. We just got to call our records and say we served her with a copy of it.
Okay.
And then I'll get you a business card. We just got to write a quick little report that we served it, and then you can have it for your records as well.
Thank you, officers or detectives. Sorry, I don't know.
No, officers.
Okay.
Thank you.
I want to.
What do you mean you don't know, Lauren? How many detectives do you know walk around in a full ass uniform like that? How many trials have you covered? Don't you interview detectives? You're eyeballing a detective right now.
I'm not that cool.
Yeah.
I'm Vovon.
Vovon?
Yes, ma'am.
And Raymer? Thank you, guys.
You're
Thank
welcome.
you. We appreciate it. You guys have. I was talking to Bobby Joe this morning. I was like, this is the first people that have listened to us.
Well, we got information emailed to us the other day,
Yeah.
so we kind of already had a heads up of what was going on.
Excuse me.
So, but with these, they're not official until you put a copy in somebody's hand.
Right. Right. And that's happened now.
So
Yep.
now she has a copy of it. I left it with her. So,
Okay. Thank you.
Thank you. And real fast, you mind if I just get your? Do you have like an ID? If I could take a picture real fast, just, like I said, just so I could put it in the report
Absolutely.
that
I
I give
understand.
to you.
Yeah.
and it's a no. It seems like it's a no contact order. So there's not allowed phone, internet, any of that stuff.
Sorry about that.
No, you're fine. We appreciate it.
I have this and a driver's license. Do you have a preference?
Whatever's easier. Probably the driver's license. Yeah, perfect. Thank you.
Okay. Oh, and there's Lieutenant. Go grab Lieutenant Hall.
Yeah, go grab the lieutenant.
Perfect. I'll get the-
So now she's confused about the officers' ranks. Are you detectives or are you police officers? Shut up.
this back to you, ma'am. And then, real fast, if I can just get your phone number, or
It is-
the phone number I called works.
The phone number, pardon?
The phone number I just called, does that one work for you?
That one.
I didn't. Selma, are you talking about Larry? I didn't see Larry Woodcock. No, I was trying not to really pay attention to the people in the background because, to be quite honest with you, I always feel bad when, people are just, random people going about their daily business, going about their lives. They get caught up in this crap because, they are in the wrong place at the wrong time because people, don't even get me started. Let me keep going.
That's my producer,
Okay.
Grayson Yor. He's on there. I'm the, what do you call it, the person that his name is official. So they have your phone number.
I'm going to say this again. I said this last night. I'm going to say it again today. Again, how many trials have you covered? This is your stalking injunction. You don't know what you are? You're the petitioner, Lauren. The defendant in this case, because it's not criminal, is the respondent. That's how it works in civil cases. The person who initiates the filing is the petitioner. The person who gets the filing and responds to the filing is the respondent. Jesus.
You want to give him mine too, probably Lauren Matthias.
Okay.
And it's
I can't even believe. Do we want to give them mine too?
but I don't want to. It'll do more. It'll do more work. Yeah.
Okay. Perfect. Yep. Like I said, we're just gonna write up a quick little report that we served to her, and then give you guys your copy that you gave us back.
Okay.
And then we'll.
She is aware that it's no phone contact, like you said. So if there's any messages that are sent, emails, anything like that, that's a violation of it.
Yeah, she's been putting threats on social media, but I think that it's on there. It says
Yeah,
on
she's
there.
not allowed to.
Lauren, they're not there to litigate your case. They're not going to be witnesses for your case. They're just there to serve it, let you know that it's been served. It's your stalking injunction. You should know what's in it. You don't need to, preserve the record. This is ridiculous.
Do any of that.
Okay.
She knows no
Annoying.
TikTok.
She knows everything. I said
She's
it's
just
a
given a copy,
I
yeah.
said it's a no contact order. I said read over it. Whatever the judge puts in here, we can't deviate from it. You will be arrested if you violate this.
Okay.
Thank you guys.
Thank
All
you.
right, thank you.
Thank you,
problem.
officers. I appreciate it.
You guys have a good time.
Thank you. We
Enjoy
feel
the rest of your weekend. Take care.
In contact.
And the contact.
You want to go to the
We feel relieved. Oh my God. Hold on. Let me see what number 5 is. Because it might just be it's probably the same thing from a different angle. I'm not going to make you guys suffer through me being annoyed for 27 minutes at all of this. Yeah, it's the other officer's body cam. If you guys want to watch it, I'll play it for you guys. That's I'm going to do whatever I'm here for y'all. So if y'all want to watch it, let me know in the chat. If you don't, let me know in the chat and we'll move on to reading the documents. Yes, that is what he said. Betsy SU. He did. Bet says, did he just say she's not allowed to post on TikTok? Because I thought that wasn't part of it. That is what he said. So after, and we're going to get to it. We're going to get to the, we already did her exhibits. So we're going to read the rest of the declarations and then listen to the court audio. And it's after they go in September. That court audio, that is when is it Betsy Sue? That makes more sense. It's hard to tell with the handles. Like if you were in here with your YouTube name, I would be fine. But now YouTube is doing these handles, which I actually think might be a good idea because people get cloned because you can have a YouTube name, but you can't duplicate a handle. They won't allow it. So anywho, Betsy Sue, that makes more sense. Spelt out phonetically. Thank you. But he changes it. He clarifies the order. So what do you guys think? Should we watch the other angle about with Lauren and Grayson and watch their duper's delight, or should we just move on to the next declaration? Because the next thing we have to read is Lauren's second her second declaration, where that's taken place after CrimeCon, and now CrimeCon is now she's really unsafe because look at what she did at the crime con. We're not okay, Jeannie. Is it coming across as hating? I'm not trying to be hateful. It's just at this point in this story, we've seen so much evidence, even in police reports, that it's not that they deemed it not threatening. They didn't see anything threatening. So let me tell you what's happened, Jeannie. Lauren from Hidden True Crime went and filed a stalking injunction. She got an ex parte hearing back in August against her former. I don't know what to call her because she says she wasn't a friend, and now, but then they were friends. So who knows? She also did a little work for her. She was a contract employee for her for a bit. But anyway, she put a stalking injunction against her. And what ended up happening is this lady, Christina, had tickets and bought them well in advance to go to CrimeCon. Lauren had said many times she wasn't going. And at the last minute, Lauren decided to go. Well, she the lady Christina was there. CrimeCon happened after the ex parte hearing where Lauren was granted a temporary protection order, and so basically Lauren had her ousted from CrimeCon. But the hotel said no, she can stay in the hotel, but she can't attend any of the CrimeCon activities, and that is what happened. So that's where we're at. So we're going through all of the um, evidence that was put forward in the um, before the hearing. What ended up happening is there was a hearing in September, and then they wanted they ended up getting a continuance until October 16th. In the interim, Law and Crime filed to be the pool camera, and Lauren was not having that. She didn't want there to be a camera in there, so she withdrew the stalking injunction, and now we're getting to it. And then Lauren did a 9-hour live, and so basically nobody knew any of this was going on. None of us were paying attention to at all any of that. The TikToker that Christina made a TikTok account and was putting like vague posts. She was making TikToks, but she used Lauren's picture, but it had a clown face over her face, or clown emoji, excuse me. And then one of the TikToks had her voice in it. But we over here on the tubes were completely oblivious to all of this until Lauren did that 9-hour live. And we were starting to hear and see some things that didn't quite jive. There were some red flags. And so, because it's, to me, if you involve the courts, it then becomes a true crime. It becomes part of it. It's not, because stalking is a crime. Cyberbullying is a crime. So for me, I wanted to look at all of the evidence and I wanted to see for myself, is this stalking? Did she, as she's been accused, did she weaponize the courts to silence somebody who was really just being critical of her? Apparently, Lauren's been doing some foul business behind the scenes. So, hey Jay, that is where we are. Hello, everybody coming in. MK Ultra, Twisted Stitch. Good to see you guys. I don't think I missed. I think I got. Hey, Kane's Nana. Good to see you. So, yeah, that's where we're at. Now we're going to read Lauren's second declaration. All right. And this is from 9/13/2025. All right, here we go. Let me make this a little bigger because I'm old. Here we go. All right. I hereby declare, under penalty of perjury, that the facts stated in this declaration are personally known to me and that they are accurate to the best of my knowledge. My name is Lauren Matthias. I am over the age of 18 years old and am competent to testify. I am knowledgeable personally about the matters I am testifying about. Right here, Lauren, I am the petitioner. You're not the official person. I am you're the petitioner. There you go. Here we go. Here's what she's alleging. Since being served with the civil stalking injunction, the respondent has repeatedly violated its terms. These ongoing violations have heightened my fear and concern for the safety of both myself and my family. The respondent's actions demonstrate a clear disregard for this court's order and a deliberate intent to continue targeting, stalking, and harassing me even while an active injunction remains in effect. After the court granted the injunction on September 4th, law enforcement officers proceeded to the respondent's residence to serve her with the order. Although the respondent was not present, her husband, Connor, accepted service on her behalf and confirmed that he would inform her of it. Accordingly, she was considered properly served in the state of Utah. Later that same evening, the respondent published posts on both TikTok and Instagram using public accounts she has previously created for the purpose of targeting me the past many months, which is in direct violation of the civil stalking injunction that states not to post on TikTok or Instagram. Links to the accounts are here. There's the links. I wonder if it'll let me click on it. Oh, it does. Okay. In one video, she sang lyrics stating, "Whoops, you messed up, ran around and then you got caught. Whoops, you messed up, now you're crying about what you lost." How dare she? I don't even know what song that is, so I'm probably not even singing it right. This is not the first time she has used that particular audio in reference to me and feels threatening. What does she intend I lose? In addition, a friend of hers commented on the post, "Time to tell the real story," to which the respondent replied, "As you wish." Oh, Lord. On the evening of September 4th, I was informed that the respondent was present at the same hotel in Aurora, Colorado, where I was staying. The following morning, September 5th, my producer, Grayson, and I met with officers from the Aurora Police Department to provide them with a copy of the injunction and to request their assistance in ensuring the respondent's removal from CrimeCon as her attendance was prohibited under the terms of the order for my safety. I was further informed by CrimeCon security that upon her arrival in Colorado, the respondent approached the head of CrimeCon security and stated that she was aware she had been served with a civil stalking injunction through her husband, yet she nevertheless intended to attend CrimeCon despite the injunction barring her presence. CrimeCon is a professional work event for me, and the respondent and her accomplices have repeatedly jeopardized my safety at multiple work related events over the past 4 months, which the respondent gloats about on social media. My fear for my personal safety in this situation was extreme. Later that same day, law enforcement officers observed the respondent walking through the CrimeCon in close proximity to where I was located. Officers approached her, provided her with a physical copy of the injunction, and informed her that she was required to leave immediately and would be subject to arrest if she returned. During this interaction, the respondent acknowledged that she was aware of the order and confirmed that her husband had already sent it to her. Despite this knowledge, she chose to attend CrimeCon in direct violation of the injunction. This is all heard in police body cam footage in the afternoon of September 5th. After leaving CrimeCon, the respondent proceeded to publish 2 additional posts on both TikTok and Instagram using the same targeted accounts. In the first of these posts, she appeared walking in a field while mouthing along to the audio stating, "And don't come over here lying on me because I'm going to tell you I'm going to tell what you said, Ronnie, Bobby, Ricky, and Mike. Don't lie on me. This is my biggest pet peeve. Do not lie on me. Oh, Lord. I can't with this. Let me check on you guys. This is for civil stock. This is a stalking injunction. This is the evidence. As with her prior posts, the comments were populated by individuals the respondent routinely engages to further her ongoing efforts to target and harass me, many of whom were at the same Crime Con Expo. In the second video, the respondent mouthed the lyrics to Eminem's song Worms. The content of this song can be reasonably interpreted as threatening. The opening lines include, "You claim if you get knocked out by the cops, you'll give them not even a statement, walk in the arraignment, shoot the bailiff, karate kick the plaintiff. Wait a minute, back the milk truck up." Let me read the second line because this is funny. The portion the respondent chose to perform stated, "Because nobody likes me, everybody hates me, they want me to go eat some worms. I hope you offended and drag my name through the mud, through the dirt. I'm going to make you eat your words." Okay, now put it in, back the milk truck up, put it in park, take the keys out of the ignition. Ronnie, Bobby, Mickey, and Mike. Is that New Edition or is that oh, it is. It is. Cool it now. You got to cool it now. All right. Didn't she act shocked on Duty Ron's that those were the preceding lyrics? Am I misremembering that? All right. By deliberately selecting and performing these lyrics on the targeted social media accounts, the respondent conveyed a threatening and a harassing message directed at me in direct violation of the active injunction. Additionally, later that evening, while I was in the bar area of the hotel, I observed the respondent standing just a few feet away from me holding a camera. In light of her established pattern of targeting me through photographs, recordings, and videos, her close proximity with the recording device was extremely threatening and placed me in genuine fear for my safety. The respondent only departed after noticing that my producer, Grayson Yor, was on the phone. At that time, Grayson was speaking with an officer from the Aurora Police Department. This conduct occurring after she had already been warned by law enforcement earlier that day demonstrates her intentional disregard of the injunction and her ongoing effort to intimidate and harass me despite the court's order. The officers had reinforced over and over that she was to be 500 feet away from me at all times. I later learned that a friend of mine who was aware of the ongoing threats of stalking had taken photographs of the incident. These photographs clearly show the respondent was standing only a few feet away from me and my producer, Grayson, despite the active civil stalking injunction prohibiting such conduct. Her deliberate proximity felt extremely intimidating and was intended to cause me fear and distress. Additionally, on September 7th, oh, it doesn't stop there. While I was seated in the bar area for lunch, I observed the respondent being escorted by security to the restaurant located directly behind me. Once again, she was within less than 500 feet of me in direct violation of the injunction. Her continued proximity placed me in fear for my safety and further demonstrated her disregard for the court's order. On Wednesday, September 10th, one of the respondent's associates, Lori H., published a video on YouTube. In that video, they specifically discussed the civil stalking injunction, using my name to identify me publicly and to emphasize that I had served the respondent with an order. You were at CrimeCon that was attended by thousands of people. The bar scene happened in front of media. Stop it. This video was created and disseminated with the deliberate intent of targeting, harassing, and intimidating me. And there's the link in the timestamp. 1846 to 2230. 4 minutes. 4 minutes. Although the video itself contained numerous false statements, the respondent publicly commented on it, writing, "Thank you, Lori, thank you," followed by 4 crying emojis. 4, y'all. 4. Not 1, not 2, 4. See, if she'd have done just 1 or 2, she might have been all right, but 4. 4. That's a lot. It's too many. That's too many. The fact that the respondent enlisted or encouraged someone to create and publish a public video about me has made me feel even more unsafe. It demonstrated not only her continued efforts to target me directly, but also her willingness to continue to involve others in amplifying the harassment. This conduct constitutes a direct violation of the civil stalking injunction and has further escalated my fear for my safety. Following the publication of the YouTube video about me, I received a threatening email and multiple threatening comments online. These communications were a direct result of the respondent's involvement in creating and promoting that video. The threats were intimidating and hostile in nature, clearly intended to cause me fear and emotional distress. Where are those exhibits? You see, I received a threatening email and multiple threatening comments online. We know that Lauren knows how to screenshot. We know that Lauren knows how to screen record. Why are those not exhibits? Why are there no exhibits of actual threats? This escalation has made me feel even more unsafe and demonstrates that the respondent's conduct not only violates the civil stalking injunction, but also incites others to target and harass me on her behalf. Exhibit 27, threats. Okay, maybe there are. For all the reasons outlined above, I respectfully plead with this court not to grant the petition or the respondent additional time by continuing the evidentiary hearing. Since this injunction was entered, the respondent has repeatedly and willfully violated its terms, both in person and online, demonstrating an ongoing and escalating pattern of stalking, harassment, intimidation, and disregard for the court's authority. Each violation has placed me in genuine fear for my safety and the safety of my family. To delay this matter any further would only embolden the respondent to continue her unlawful conduct and prolong the danger and distress I'm forced to endure. I therefore respectfully request that this court proceed with the evidentiary hearing scheduled for September 22nd. All right, let's see. Exhibit 25. Okay. Now, oops, let me make this a little bigger. All right. Let me make this like this. So, here is the picture. Here's Christina, here's Grayson, and here's a poor, unfortunate couple just caught up in the middle of this. I'm not sure who this is. Here is Christina clearly being threatening. Now, after this has come out, now that all this has been made public, I want you guys to look here at this from Joe. Joe is none other than Joe Schmo, who has a YouTube channel. Joe Schmo went on Queen Bee's panel and proceeded to explain to Queen Bee and 1,500 of her closest friends that they had come into the bar after the fact. Christina was already there. That's number one. But also, they continued to scooch closer and closer and closer. Okay? So let's keep that in mind because other things have come out after this that don't look good at all. And just in case you didn't know who everybody was in this picture, here's a circle and here's a circle. And there was quite a lot made that Christina was in a bar in her socks. I'd like for you guys to please look at this bar. Okay, this is not the club. This is a hotel bar. It's open. Okay? Like, calm down. Who cares if she wore her socks? I mean, it doesn't seem like a safe thing to do given the fact that they're socks and that the floor is wood. I mean, if there was like a situation where you needed to run, it would be problematic. Okay? But other than that, like, I don't understand. All right, exhibit 26. Oh, she thanked her, and 1, 2, 3, 4 crying face emojis. 4. Here's what she's really mad about. I'm sorry, Lori, Gigi, and anyone else she is affecting. I have followed you since you started with her, then went on your own channel, then went on your own. I continued listening to you. Dropped her. She always struck me as phony. There you go. There's where it's the big mads. Okay, here's a comment. I understand petty drama occurred at CrimeCon. How unfortunate and disappointing. The audacity. I have no idea what this is. Lauren Knott shot her face after her behavior at CrimeCon. She lost subscribers. I don't know what that means. Here's so blocking other creators from attending CrimeCon with stalking and complaints. Explain that. Tell us about CrimeCon. Who was stalking you? Why did you call the police? I mean, those are questions. This is gibberish. I mean, I don't understand where the threats are. Um, yeah, I mean, look, it happens, women's shoes, people, I don't think, everybody knows. You guys have all been there, done that. Um, you know, it happens. All right. I want, let me read this. Here's the ex parte motion. I want to read this. No. Oh, this is for sanctions. This is another ex parte attempt. Okay. On September 4th, 2025, this court issued. Hold on a minute. Huh. Sorry, you guys. On September 4th, 2025, blah, 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 and temporary civil stalking injunction against respondent Christina, which contains specific orders prohibiting stalking behavior, contact with petitioner, and specified individuals and requirements to stay away from petitioners' homework and other specified locations. Let's see, respondent has willfully and repeatedly violated multiple provisions, beginning the very same day she was served, as detailed in the second declaration of Lauren Matthias and supporting exhibits attached hereto. This matter is urgent, as respondents' violations are escalating in frequency and severity, placing petitioner in immediate danger. I would like the record to reflect. Oh, I forgot to share this one. Sorry. I would like the record to reflect that none of those, the only thing that Christina wrote herself is thank you with 4 crying emojis. Everything else came from other people. Okay. That's the point. That's the problem. All right. Okay. The CSI issued by this court on September 4th specifically orders respondent to personal conduct order, not stalk the petitioner, including not following, threatening, annoying, or harassing the petitioner in any way that would cause a reasonable person to suffer emotional distress or fear for their safety. No contact order. No contact, phone, text, mail, email, or communicate in any way with petitioner and the following protected persons: John Matthias, Grayson, immediate and extended family, business, coworkers, employers of true crime podcast docuseries. Stay away. Petitioner's current or future home address safeguarded. Well, we didn't need to see that. Petitioner's work address, petitioner's vehicle, online forums, and other social media accounts. See, this is where I think it got messed up. Online forums and other social media accounts. I believe they're referring to Lauren's online forums and Lauren's social media accounts. But this, they banned her from the whole crime con. Additional orders not come within 500 feet of the petitioner, which she didn't go into the crime con expo. She was at the hotel. Her immediate and extended family, coworkers, employees, or places of business, cease and desist any and all online activity and communication, direct or indirect, relating to, referencing petitioner, her family, coworker, or professional associates. That the violation of these orders is a criminal Class A misdemeanor punishable by up to 1 year in jail and a fine, with second or subsequent violations resulting in more severe penalties. Despite being served, respondent has engaged in multiple willful violations of the court order as documented in petitioner's second declaration and supporting exhibits 22 through 27. Later that same evening, she was served. This is her published post, the lyrics. Respondent traveled to and attended CrimeCon Expo, which was specifically prohibited by in the CSI. Approached CrimeCon security, acknowledging she was aware of the CSI but intended to attend anyway. Was observed by law enforcement walking through CrimeCon in close proximity to petitioner's location. When did that happen? When confronted by officers, admitted she knew about the order and that her husband had sent it to her, was physically served again and told to leave immediately or face arrest. That's not what she was told. After being removed from CrimeCon, posted 2 more videos on TikTok and Instagram. First video, mouth to audio stating, "Don't lie on me," with threatening undertones. Stop it. Worms. She's mad about worms. Stood just feet away from petitioner in hotel bar area while holding a camera, only departed after observing petitioner's producer on phone with Aurora police. Let me say this, okay? You can see from that picture that they're looking at the phone. She can't tell who they're on the phone with. Stop it. Ridiculous. Okay, on September 7th, she came within 500 feet. We've already been through this. Thank you, Lori. Thank you. Blah, 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 blah. Let's see. All these are supporting. We all watched the body cam footage. Most of the things that you said are declaring are incorrect. It didn't happen that way. Let's see. They want, therefore, or wherefore, petitioner respects, this is what they want. And they want them to issue an order to attend hearing requiring respondent to appear personally before this court to explain why she should not be held in contempt for violating the civil stalking injunction. Find respondent in contempt of court for willfully violating the court's orders at least 6 documented occasions between September 4th through 10th. Impose the maximum sanctions, including a fine of $1,000 each for each violation, totaling at least $6,000. Confinement in jail for 30 days. Payment of all petitioners' attorney's fees and costs incurred in bringing this motion. Payment of petitioners' travel and security costs necessitated by respondent's violation. Convert the temporary CSI to a permanent CSI for full 3-year statutory period, given respondents' immediate and repeated violations. Modify the CSI to include increased distance requirement of 1,000 feet, explicit prohibition on directing third parties to harass petitioner, prohibition on creating any new social media accounts. She wanted her GPS monitoring if technologically feasible. Immediately refer for criminal prosecution. They wanted her prosecuted criminally. They wanted a bench warrant if the respondent fails to appear at the hearing, and grant such other further relief as the court deems necessary. This is absolute ridiculousness. Complete ridiculousness. All right, let's see. Let's listen to the court audio. I don't want to keep you guys too long. All right, you ready? You guys, you think you're ready for that? Should we do the court audio? Yes, I'd like to know, Betsy Sue. And I know you told me to just call you Betsy, but now I need to say Betsy Sue because I think it's so cute the way you spelt it. I love it. Shmita, hiya, Shmita. How are you? Hi, Shmita. All right, now, should we hear the audio? Are we ready for the audio? Because this is absolute bananas. I cannot even believe this is. These are the evidence. This is the evidence. All right, here we go. It's loading. All right, there's nothing to look at, but I'm going to share this tab anyways. All right, are you guys ready? It's turned up all the way. I know the audio's not the best, but here we go. Give it just a second. It's doing its thing.
04055.
Here we go.
Can I get counsel to state their appearance for the record?
Dastan Dio for the petitioner.
And James Dunkelberger, the law firm of Bennett, Tueller, Johnson & Deere for the respondent. And respondent is seated with me at counsel table, Your Honor.
Thank you. We state your name again.
James Dunkelberger.
Dunkelberger?
Yes, sir.
Okay, counsel, before we get going, do you want to proceed by proffer, and I'll put your clients and witnesses under oath and see if they'll affirm it, or do you want to call up witnesses, cross-examine, direct examine?
I think witnesses, we would prefer calling witnesses not proper.
Okay. We are set for an hour hearing, so use that as you see fit. I notice I did have a motion to allow some witnesses to appear remotely.
Yes, Your Honor, that's our motion.
Are they out of state?
Yes, they are.
Okay.
Petitioner also had a motion to allow one of our disabled witnesses to appear remotely. The court granted that motion, I think, this morning and provided the link. But we did have a request outstanding for other witnesses to appear if necessary remotely.
So you guys would stipulate to the witnesses appearing remotely?
I have no objection to that.
Me neither, Your Honor.
Okay.
Your Honor, if we could just revisit the schedule today, though. There are several declarations filed on each side. Several witnesses probably intend to appear today. 1 hour is an awful short amount of time to get this all done, and if we are going to try to do it in an hour with live testimony, could we have some sort of a guidance from the court on how we split that up, or how our time is to be spent today?
Yeah, you guys choose how. I mean, I'll make it even, that it's 50% to each of you as to how you want to go about it. I noticed that there was several declarations filed in regards to this. Have the parties had any communication?
No, Your Honor.
A little
The
bit of
parties
procedure,
themselves.
yeah.
Okay.
Forgive me, maybe I misunderstood. Do you mean counsels?
Yeah.
Counsel for party?
Yeah.
Minimal
on procedural matters last week.
How come there's been no effort to resolve this? Is there a reason why?
Well, from my perspective, it's not that we're against that or opposed to that. It's just the timing of it has been so short between when the injunction was filed and when he appeared, and so there's been a lot of evidence and other briefings to submit and worry about. So we haven't. I would just say it's only because we haven't had a fair chance to do it.
Okay. Well, let's go ahead and get started. Unless you guys think that some discussion, I can give you a little bit of time if you want to go out and discuss. If you think that would be fruitful. Otherwise, we'll just get going.
I'm happy to go out with this stand and try to have a quick discussion.
Okay. Why don't you guys do that and then come back in and let me know.
Okay. Thanks, John. 5 minutes, 10 minutes?
Yeah, 5, I mean, you can tell if we're making progress. As soon as you can see that we're going one direction or the other, let me know.
Thank you, Your Honor.
Okay, so spoiler alert, nothing gets
may have a
resolved.
seat.
They're back.
Okay, counsel, what we're able to work out.
Not a,
Unfortunately, Your Honor, we're not going to be able to come to a stipulation today.
not a damn thing.
Let's go ahead and, are you ready to proceed then?
We had one matter of housekeeping, Your Honor, from the petitioner, if that's all right, if I may.
Go ahead.
So, given the nature of the claims and the emotional distress it's caused to my client, and considering the audience we have here, my client is requesting that only the necessary parties, those from the respondent's side who will be testifying, be allowed to be in the courtroom, to provide her some sort of safety and comfort during these proceedings, to the extent we can.
Safety and comfort during the proceedings. Put a 1 in the chat if you have ever watched a trial in your life, either in person or being streamed. Please put a 1 in the chat if you've ever done that in your whole ass life. It's after 10. I'm fixing to get spicy. Let me know in the chat. Have you ever watched a trial, either in person or being streamed? Please put a 1 in the chat if you have. I see the ones are coming in. Here they go. Here they go. Besides the judge, the clerk of courts, and the stenographer, what other court staff are in a courtroom? A bailiff, right? Aren't bailiffs armed with a firearm? How much more security do you need, Lauren? What do you think this woman is going to do? Climb across the table and knock your block off? Stop it. Look at Christina. She weighs what, like 105 pounds soaking wet? You don't think the bailiff in the court could stop her? I don't know. You don't think the attorneys that are in between the two of you could stop her in time? Get out of here. Absolutely ridiculous. Add additional security and comfort. Let me tell you why this is irritating to me, okay? Because it's bullshit, okay? It's absolute bullshit. She is asking for some type of accommodation that even Dylan Mortensen, all of the victims really, who gave victim impact statements, but particularly Dylan, who, bless her heart, all she asked was if she could sit down and not be at the podium while she read her victim impact statement, okay? That's a victim, Lauren. You are not. Stop it. Absolutely ridiculous. Absolutely ridiculous. Hey, Tanika. Yes. What was it, Tanika? Oh, yeah. What was it? Oh, Taylor Shabusiness yelled. WrestleMania! Is that what you thought was going to happen? I mean, come on. Ridiculous, ridiculous, ridiculous.
Okay. Mr. Dunkelberger?
Yes, Your Honor, we'd object to that. This is
This is a public hearing. You know, Taylor Shabusiness pled
petition that's
guilty.
been brought by petitioner. She's going to be here in the courtroom, and as respondent, Ms. is entitled to have people here with her. And
Yeah, it's an open courtroom. There's no motion filed to close it. So, and I expect the parties to be here in person when we have a case. So that motion is denied.
Okay.
Now, as to the reality of where we are, how much time does counsel think that realistically you're going to need in this case?
Well, we need at least 2 witnesses, 3 including the petitioner's husband. I'll try to get through them as quickly as I can, but there are
Well, how
some
much time are
lines.
you anticipating?
Boy, Your Honor, I had anticipated having the whole day, honestly. Or at least half the day.
When did the notice go out?
This was continued, if I remember correctly. This was scheduled for last Friday after work.
That's correct, and then it was rescheduled to Monday the 20th, from the 17th to the 22nd.
So I'm not sure why when we scheduled it at 4, why you'd anticipate you would have a half day or a whole day.
You're right, that I might have misread that, or read too much into it, but it was rescheduled for 11 a.m., so.
So how much time are you anticipating? That's
Hours.
how many hours?
At least 3.
On your case in chief?
Yeah.
Mr. Dunkelberger?
So we were prepared today because of the short time frame to proceed primarily by proffer. We understood that that's what was going to happen today, given the short amount of time. Brief opening statement, proffer the witnesses, some cross-examination in a hurry, and then be out. We are prepared to accordion to the court's convenience on this. Certainly, if the other side's entitled to 3 hours, we'd ask for parity, but we think that you could do it in substantially less time. It just depends on how they want to do it.
Okay.
I have a suggestion, Your Honor. Pending before the court is our ex parte motion to enforce the temporary civil stalking injunction. Perhaps if we proceeded to resolve that motion, that may resolve the entire matter. In other words, I guess what I'm saying is perhaps we can achieve what we need to by simply ruling on that motion, and then if it's granted, then that resolves the issue, and if it's not, then we can, I guess, readdress and plan at that point.
Mr. Dunkelberger?
That's the tail wagging the dog, Your Honor. I mean, we have 28 days, from the notice. As far as I'm aware, I don't think the court has issued a hearing. I know there was a request to expedite it. I didn't really see grounds to expedite it. There's some pretty serious allegations, and frankly, we were expecting it would go the other way around. If today the temporary order is not extended and made permanent, then that's going to make the court's resolution of that issue a lot easier.
Well, it would also make it moot, because if let's say I ruled in favor of your client, Mr. Dale, on the motion to enforce, and then later I ruled that there shouldn't have been a stalking injunction, well, I guess that can go, because there is an ex parte one in place. Okay, have a seat. Let me think through something. Thank you for your arguments.
Your Honor, may I respond to one thing he said?
Sure.
Thank you. The standard that is applicable to the ex parte motion and the enforcement of the temporary civil stalking injunction is completely separate and irrelevant to the issuance of a permanent stalking injunction. The temporary one was issued, and it was effective, and there were violations of it. Whether or not the court decides to continue that and issue a permanent stalking injunction is a separate question. So I would argue that we can proceed on just the ex parte motion today.
But didn't I just see a request to submit just barely filed on 9/17? So just 5 days ago?
I'd have to check the date myself, Your Honor.
Yeah, that's what I saw. So I do think that there is a preparation time. We do have to give due processes if they weren't prepared to argue that today. It's not fair to throw it on them and put that in there. Let me just look at a couple things here.
Your Honor, I'm just going to grab my client.
Oh, for the love of Pete. What is happening? Who do you think has the main character, potential main character syndrome, Humanimal? I'm curious. Oh, babe, I'm sorry. I care about y'all. I'll be checking. Oh, there's no way to, like, move forward through this, like 10 seconds or, you know what I mean? Which I'm not complaining. I'm grateful for it. Otherwise, I would just skip. But it doesn't really work like that. I should have maybe downloaded this myself. I didn't know that we would get to it tonight, honestly.
Okay, counsel, here's what I'm going to suggest.
Yes, Humanimal,
we
that is
do.
how to describe it.
In light of, it doesn't sound like, typically on these, we have limited witnesses or they proceed by proffer. It doesn't sound like either party, well, it sounds like one party is willing to proceed by proffer, the other wants to call witnesses. And we certainly do not have enough time to do it today, to get everything in. So what I'm suggesting is
No, there's no way to speed it up. If I would have downloaded it myself, we could have, but I'm sorry I didn't.
I'd like to set this for October 16th. And in that time, I could give you, I can't give you the whole day, but I can give you a good portion of it. Does October 16th work?
Counsel for petitioner is available that day, but my client's still checking.
Oh, for the love of Pete. Come on, Lauren. Get it together, sis.
It works scheduling wise, but I'm going to object.
And he should object, and here's why. Okay? Because that initial stalking injunction, the temporary one, was very vague, and very, very restrictive in light of the circumstances and in light of the evidence presented. Okay. And I'm not an attorney. I don't pretend to be an attorney, but I mean, I have to agree with him. I would have objected too, because we're going to drag this out another month. That's poppycock. I would be like, nope. I would be singing that song. Hail to the no, no. All right, here we go.
Okay. Mr. Dunkelberger, I heard you say you're going to object. Go ahead and state your objection.
Yeah, just for the record, thank you, Your Honor. It was noticed for today. We asked for a stipulated continuance. We didn't get it. We moved for continuance. It was continued 3 business days. We have witnesses here from out of state to be sworn in to testify regarding their affidavits to proceed by proffer. It was scheduled patently for an hour. If counsel was unprepared to present petitioner's case within the time allotted, then it was sort of incumbent on him to contact the court and to determine how much time would be available. In the meantime, my client's civil rights have been severely impeded by the temporary order. We'd like to have her day in court. A continuance of almost a month severely prejudices her. We've got that's recalling witnesses that have come from out of state. And we prepared because the court told us to be in court today, and we prepared for the time that the court had to give us. And it's simply prejudicial and unfair to respondent to have it continued at this point, particularly when counsel had every opportunity to stipulate to a continuance and make sure that the court would have time to hear hours of testimony. And that's our objection, Your Honor.
How many witnesses do you have from out of state?
We have 2 here today.
Okay. Mr. Dale, do you want to respond?
Yes, thank you, Your Honor. I don't think it's fair to put that on us. I mean, the hearing was set for 11 a.m. I'm sorry, but and there was no mention or notice that it would only be an hour. I apologize, but we were prepared to examine many witnesses to prove our case. Counsel had the same information. Opposing counsel had
Look, here's the deal. You can examine 11 billion witnesses, okay? Let me tell you what you're missing. You're missing the connecting of the dots. What you needed here to prove your case, you don't have. You don't have a paper trail of any kind. Not in screenshots, not through texts, not through emails, nothing. You have not a shred of evidence that connects Christina to putting Lori Hellis up to making a YouTube video. She was at CrimeCon. This happened in front of God and everybody. What is your, people were going to talk about this. They were. Yes, he does. Little bit of Lisa, he does. We're just not there yet. You can have anybody and everybody you want to get up there and say whatever they want to say, but at the end of the day, there are heavy allegations. You have alleged in your declarations and through and in your and then you offer these exhibits as if they're proof of something. They're proof of nothing. They're proof. There's no proof that Christina worked in concert with anybody. I have a YouTube channel. Okay. I have friends on YouTube. If I make a video or if I do a live, my friends will come in and they'll comment in the chat and they'll comment in the live. But you know who else does? Every freaking buddy else that has access to the internet and gets on YouTube and stumbles across my channel. Am I responsible? Did I tell all 50 people? 45 of 5 of them are my friends, people that I actually know, and the other 45 people that I've never met, and this is their first time on my channel. Somehow I'm responsible because and I worked in concert with them to get them to put comments in my channel on my videos. Are you kidding me? That's not how this works. That's not how any of this works. It was restrictive we read what they were asking for. So their claim is that she violated it by just being at CrimeCon. Their claim is that she violated it because she knew that there was a stalking injunction. She spoke to the security at CrimeCon. Mind you, she initiated all of this. But the way that it was interpreted at CrimeCon was restrictive, given how vague the order actually was. That's a better way of putting it. Because they put in that order business associates.
same information we did.
They put in that order business associates, but never named the business associates, which Christina very correctly and astutely pointed out. She could say anybody I could be talking to anybody and Lauren could claim that they're a business associate of hers. And therefore I'm violating the stalking injunction. I just worded it kind of, this is why I'm not an attorney, because I can't word things correctly. All right, here we go.
And to assume that he could call in witnesses today to examine them all in an hour, I mean, it's equally to blame. That's not a reason for to say that he was prejudiced. So, Your Honor, I guess I defer to the court on that. But,
okay, here's what we're going to do. What I'm going to do is we're going to get this on the record. We've got 2 out-of-state witnesses. I'm going to bring their testimony. I'm going to have you put them on the stand. We're going to continue this for the morning of October 16th. We're going to put these two witnesses on the stand right now, and we will let them testify. You can cross-examine them. Everybody should be prepared to do that because we've discussed it. And then we can, because your argument, Mr. Dale, is, hey, we were planning on putting on all witnesses today and have them testify in cross-examination, so there shouldn't be any preparation issue there. You've indicated you're prepared, Mr. Dunkelberger, to move forward with those two witnesses. So let's put those two witnesses on the stand, then we will continue this until October 16th, beginning at 8:30, and expect that it will be done by 3 o'clock on the 16th. Sounds like that did work for everybody's schedule. Okay, any questions?
No, Your Honor.
Okay.
Okay. So Carolina says, if I remember correctly, Christina didn't know about it until the cops showed it to her at CrimeCon. Okay, so it's a little convoluted, but in the body cam footage, Christina says that her husband told her that she got served with something. Then he sent her screenshots. And she did know that she had it, but under Utah law, there's no, I guess you can ask for this, like for her husband to have accepted service in her place because she wasn't at home and wasn't going to be at home. She was flying to Colorado. And, but they didn't do that. So she was unclear about the stalking injunction. So she asked the Aurora police and she asked the CrimeCon security because, you know, so she did know, but what she didn't know is what all it meant. And she was trying to get clarity. And at the end of the day, the way that the law works in Colorado or in Utah is that she had to be served directly, and she wasn't. So she herself had not received the actual order. She got screenshots and, or pictures of it really, because probably took, and that's a hard picture to take. So, yeah. But we're going to skip ahead. Hold on. I want to hear
Mr. Dunkelberger.
he says at the end.
Yes, thank you, Your Honor. We'd like to call Janice to the stand, please.
I'll let you guys listen to this audio on your own. Like, I want to show you guys at the end
For
because
that purpose.
hold on.
That is not what a stalking injunction is for.
Hold on, I went too far. Because it's the end.
Communications relating to or referring to the petitioner,
Make-
her immediate family and extended family.
Hold on. Because there's argument being made that all of us who
Okay, that's right.
all of us who heard the judge say that it appears that a stalking injunction is not the correct remedy for speech that you don't like, basically. That we've all heard it wrong. We've all taken it out of context. It's part of a larger conversation that we're only clipping this one little tiny part and thinking that it means something that it doesn't mean. So I want us to hear it in its full context and all the things.
Right. She does freelance work for some national news
Hold on,
outlets.
I got to
with her
rewind
about.
it just a little.
So she can get on those now.
Because this is what I want us to hear.
Email or any other communication directly or
Use them as a cudgel when we get finally to court for the full hearing, which we thought was going to happen today.
Come on. I wish I would have timestamped this. I'm sorry, you
obviously it
guys.
seems like your client's primary concern is that this impacts her ability to make a living.
This is very unprofessional of me. I apologize ahead of time.
I did. I have not received any videos contrary to, or any. I haven't received the evidence that he claims to have produced. I haven't seen it in my inbox. I haven't seen any notices filed with the court that they were produced.
Your Honor, I'd be happy to provide the email that we provided Mr. Dill.
In any case, even if they were provided, it was just last Friday. I haven't had a chance to review
Yeah,
it.
this is the problem with the cramming that's going on. Is we do have some real due process issues. First of all, are we done with Ms.
Yes, Your Honor.
Ms. Let me step down. Thank you. I'm going to withhold admitting those right now, and you can make that motion again when we motion to admit. I don't know that we need anything else from this. You're relying on her declaration to lay foundation. So I'll withhold admitting them. Are those that, you guys can sit down, are those the two witnesses we need today?
Yes, Your Honor. Just revisiting that issue, though, I mean, the issue that I'm having is I'd like to make a motion to dismiss the temporary restraining order today. Again, almost a month is a long time for a temporary order to last, and I think that particularly Defendants 12, the Boise Police Report, is really central to the way that Ms. Mathias obtained the temporary order in the first place. She represents...
So that's going to be hearsay. I mean, let's talk about that. That's one of
Sure.
the things. That police report is hearsay, and her testimony doesn't get you past hearsay.
Well, so her testimony can lay, and if you'd like, I can absolutely lay foundation for how she received it. It's a business record. The police have kept it in the ordinary course of
You don't
business.
have an officer here.
This is a civil proceeding. That's right, but she can testify that she received it directly from the police along with the other videos and things that the petitioner submitted. And with that, it's kept in the ordinary course of business. It is a police report,
But she couldn't lay foundation, and you might look at it, she can't lay foundation that it was kept in the regular course of business.
Okay. So that she can't, I mean, obviously the judge is correct, right? See, the thing is, even in a civil trial, you got to show how that evidence, how the evidence came to be. Okay. And yeah, you can request your own, if you make a police report, you can request a copy of that police report. Okay. But if you want, and you can have it, you can request the body cam and you can have it. But if you want it submitted in court as evidence, you have to show how you obtain that. And that's why that's why when we're watching a court proceeding, a lot of times they'll have like 3-4 cops that are boom, 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 real quick, because they're testifying. They're only there to lay the foundation. They're only showing that they're kept the records, that this is where they're kept, blah, 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 like that this is their body cam footage. Okay. They're not actually that's it. That's how they get the body cam footage in. The officer whose body cam footage it is comes and testifies. They ask him, some basic questions, was your camera on, blah, blah, blah. We've all been there in a court. We've all seen it, but it's that the way that Lauren is doing it would be like the defendant going and requesting in a criminal trial, right? The defendant going and requesting the reports and trying to get them in themselves, I guess, is the best way to put it. I know it's funny that it's
She's not
hearsay.
the records keeper for the police department. I mean, and really, let's go to your primary point. I don't want to get caught up on that. Your primary point is that you've got some issues with the temporary stalking injunction being extended during this time period. And from your arguments previously, it seems like your client's primary concern is that this impacts her ability to make a living.
Yes.
And her free speech rights.
Yes, Your Honor.
Talk to me about the free speech rights. How does this impact her free speech rights?
Okay, but Neat says, I used to have to go in and testify on child support records all the time as a rep from the agency, even though I didn't generate the records. Yeah, but you worked at the agency. Lauren doesn't work at the police department. Okay, so Tanika say, I may have missed this. Was there an October hearing? Let me tell you what had happened. Yes, they scheduled an October hearing. There was a hearing scheduled for October 16th, 2025. Prior to that hearing, Law and Crime filed to be the pool reporter, the court to video the proceedings, okay? Not stream. The request was to video the proceedings, okay? When that and they asked, Lauren, the petitioner in this case, said, "No, no, no. We do not want that. We don't understand it. We don't know," because initially they didn't even know who did it. It came out later that it was Law and Crime, but she didn't want it um, recorded in any way, shape, or form. And the judge allowed it. And when the judge allowed it over her objection, she withdrew. So there ended up being no hearing. She withdrew everything.
Yeah, so with that, Your Honor,
And I read your case law. I want to know factually what in the stalking injunction prevents her from saying what she's saying. Go ahead.
Sure, Your Honor. Well, so, and we don't believe that it does, but petitioner has alleged that by posting videos, again, without using the petitioner's name or her likeness, that she has violated the temporary order. Now, the amended temporary restraining order does say to keep off online. The respondent understood that to be, do not contact her on TikTok, do not contact her on Instagram or on any other platform. The allegation is simply by referencing, making a post that's related to the petitioner online, that she's somehow violated the temporary order. There's 3 videos that they claim have already violated it. That's 3 of the 6 alleged violations that they're prepared to talk about today. And so there's got to be some clarity there. That just doesn't jibe with Towner or with Fischler. Certainly the First Amendment allows talking to third parties or the public about somebody. That's Towner v. Ridgway. That's been the law for a long time. Fischler reiterates it. It's just plain letter law in Utah.
I'm sorry, Nate. I guess I misunderstood what you were saying. And so Nate says, agree the ward. That was my point. The parties couldn't testify to the records. They had to have an agency rep, just like we could get an officer to testify to the records of other officers. Right. Like, yes, that's the thing. And this is another thing, Tanika. No, we're going to see how, okay, so the temporary order didn't expire. We're going to hear how that goes here. They don't drop it because there's going to be a continuance. What they did in this hearing at the end was modify the temporary order substantially. But then she's the one that after her continuance wasn't granted, and then Law and Crime wanted to there was, if it came out later, like I said, that it was Law and Crime, but there was going to be media, and Lauren initially assumed that it was some small YouTube channel, who I don't know, but whatever, that's what she assumed. They found out later that it was Law and Crime. But anyway, when the judge said, yeah, this can be recorded, that's fine, she withdrew it completely. So now, yes, yes, it's crazier than everybody thought. And let me just say this, because I forgot this part, because this is very important. On October 15th, she'd already withdrawn at this point. Okay. The hearing was scheduled for October 16th. On October 15th, she went live, Lauren did, on their Hidden True Crime channel, and did a 9-hour live. She said many things, showed many things. Okay. But the one thing that she conveniently left out was what happened during this hearing. This hearing, if I'm not mistaken, takes place on um, the I feel like September, sometime between the 13th and I'll say like the 21st, somewhere in that time frame is when this hearing took place. But in all of those 9 hours later, she never mentions this hearing at all. She did. You're right. That let me be very, very clear. She said a whole lot of nothing showing stalking. Well, little bit of Lisa says, "I'm sorry to disagree. I think the judge only clarifies the order, but he does not modify it." I think okay. When John and Lauren went live, last Saturday, and gave their response, because by last Saturday, all of this had come out. The court audio had come out. One of the things that Dr. John was huge mad at was and these are his words. He said the judge modified the order, the temporary stalking order, without hearing from Lauren. So, and that's what they're like talking about right now. And so let's hear it, because you know what? John could have gotten it wrong. Dr. John could have gotten it wrong, and I could have interpreted it wrong. So let's, and you could be right. Listen, please never, ever, ever, ever apologize in this chat ever for disagreeing. I love it when people disagree. I'm not always right. I don't and my perspective and perception of the evidence isn't the same as everybody's. And Allie will tell you, when she really believes something, she will be like, Bindi. And then she'll explain it to me, and we'll figure it out. So don't ever apologize for disagreeing. That's what these are. We can't learn if it's an echo chamber. So I love it. Keep disagreeing with me.
She hasn't communicated through these posts to or specifically directed at the petitioner, and for that reason, I mean, she's basically gagged online at this point, according to petitioner. Now, we're hoping that the court determines and agrees with us that you can't interpret the amended temporary order that way, but certainly they've alleged that on the language on its face that she's not allowed to go online and to post anything related to the petitioner. And obviously that's got First Amendment issues, and practically it's unfeasible. Everybody goes online and everybody can comment with their friends. Instagram, TikTok, those are ways that we communicate these days, and certainly Ms. McCoy is entitled to communicate to her friends and followers via these online platforms. And it's simply unfair to go another 3 weeks just allowing petitioner to collect videos that have been posted that are First Amendment protected and bring them and use them as a cudgel when we get finally to court for the full hearing, which we thought was going to happen today.
Okay, thank you. Go ahead and respond.
I have to object to the characterizations he's made on behalf of myself or my client and our positions. The evidence, like we're getting lost in weeds. The motion he made was based on the declaration, the testimony we've heard in the declarations, that the court should suspend the temporary order. But there is no evidence to suggest that. Like, that's not the question. The question, Your Honor, is whether or not my client has the burden to prove that it should continue. There's been no motion to set it aside at this point. So that's improper. That's not properly before the court. The rest is just argument and representations.
Why would he file a motion to set it aside? He thought he had a hearing today to deal with it in full.
Well, I'm just saying procedurally. There are procedural ways to do that. Those haven't been met. Satisfied. The other arguments about what's been said online or what they're about have yet to be proven and shown. Virtually all of what he said is not based on evidence that is before the court today. So the court can't make that ruling today.
Okay, thank you. Go ahead.
Yeah, and with that, Your Honor, this is a motion. When we're making it, we learned minutes ago that this is going to be extended for another 3 weeks, and this severely impacts respondents' civil rights. I mean, this is what we have. I mean, at a minimum, we need a clarification for the amended temporary order that that makes clear that she's entitled to go online and talk about whatever she chooses to talk about online, and that certainly can't be a gag order that it has extended, that we're going to be on for a motion for sanctions about, and then that's going to go for another 3 weeks now.
Your Honor, I would object to the characterization of the language of the civil stalking injunction itself. It's not what he represents it to be.
Well, I'm reading it,
and
it's my order, so I'll make the interpretation of it.
Sure.
Okay. I do have, I'm not sure how this was interpreted, but let's go back to the purpose of an ex parte temporary order.
Okay, so what are you saying says, where's Christina? Has she posted any replies? Can she post now and just isn't? I'm lost as usual. She can post now, she just isn't. Oh. Daisy Bree says, let me start over. Hold on. Let me go back to the beginning. Hold on a second, Daisy. I want to get your okay, because they're doing daily live stream on this. Well, I'll tell Daisy, I don't have an email from you, babe, but I'll tell you what. Here's I'll put the email link in my in the chat right now, and email me. This is the last time I'm covering this, so I'm interested. I would like to hear it. So yeah, send it to me. Absolutely. Absolutely. Thank you for reaching out. I appreciate that, because I'm always looking for true crime cases to cover, but I started this and I feel like I have to finish it and then I'm going to be done with it. All right, here we go.
That is to stop any harm. Specifically, we're looking at ongoing threats or physical harm that could happen. It's made without all the information. It's made simply basically from one side, providing the information. As the ex parte order right now, it prohibits personal contact and prohibits threatening, annoying, stalking, harassing. That will remain in place as is. As to the no contact order, that will remain in place. Specifically as to the text, mail, email, or any other communication directly or indirectly. In other words, I don't want them talking to each other. Now, it does identify other people and family members for sure. So Mr. Mathias is sure going to be covered by that. As to Grayson Yore, is there any reason that your client would need to contact Mr. Yore?
Miss Yore, but no.
Oh, excuse me, Miss Yore, thank you. Okay, then Miss Yore's included on this. Son is covered by this. So that will remain in place as well. As far as the stay away order portion of it, stay away from her home, that will remain in place as well. Is there any reason why she would need to go to near a job site or a school of Ms. Mathias?
Well, no, but just to clarify, I mean, there's public places where they both may
I'm going to
think.
deal with that.
Okay, so no, not in Henderson, Nevada.
Okay. And then I think this is the provision that may be misinterpreted here.
Okay. Hey, Crusha, good to see you. Difficult Research says, I'm just getting here. The ward case studies. Hey, lady. I got to get work done and listening in the background. Holla if you need me. Thanks for continued exposure. You're welcome, babe. Good to see you. Get your work done. And I do see a young Black economist in here. Good to see you as well. Thank you guys, everybody, for being here. I really, really appreciate it. This is where it's going to get important. I think this part of it is where for me, it's important. All right, here we go.
That she's prohibited from online forums and social media accounts. But that was in kind of in parentheses, TikTok, but then it says down there the 2025 CrimeCon Expo that was in Denver, Colorado, September 5th through 7th. When I was reviewing this, that was what I was looking at, was that CrimeCon. I in no way intended that the respondent was to be kept off of social media sites. I do think that's freedom of speech issues, and I don't think that this order was intended to cover that. So she can get on those now. I guess she runs the risk if she's on those and those are interpreted as annoying or harassing. Although I will say that's a fairly high bar in the sense of just because somebody says something you don't like, that's not going to be a violation of a stalking injunction. And there would have to be directed comments that were clearly meant for a specific purpose. Yeah.
Okay, that last thing that he just said there is important. It's a high bar. It's not just, it's like the example that I gave earlier, okay? There are 149 of you guys watching this right now. It doesn't like I think more people are watching than are actually actively chatting, okay? Of the people that are actively chatting, there are a few people that are actively chatting that are new. I haven't seen their names in my chat before. Welcome in. Thanks for being here. And of the people that what he's trying to say is that if Lauren were to take my chat, for example, and hold me personally responsible for everything that you guys said, as if I directed you guys to write it in the chat, that's what she's doing with those screenshots.